everyone, and welcome back to SEC Roundup, our special Thanksgiving edition. With us today, as always, Nick Morgan, the co-founder of ICAN. Hi, Nick. How are
Hey,
you?
good morning, Tom. Doing well, thanks.
And we have a very special guest today who's going to discuss her organization's recent blockbuster victory in Texas. It's Marisa Coppel, the head of legal for the Blockchain Association. Hi, Marisa.
Hi, Tom. Thanks for having me.
So let's jump right in. We're going to talk about the Blockchain Association's recent victory against the SEC in Texas. So, Nick, why don't you tell us a little bit about the case?
Yeah, so Tom, as you'll recall, this is a long-running issue. This rule the SEC passed back in February. We actually had somebody on from the hedge fund industry from AMA, Suzanne Rose, back in February when the rule came out. The private funds groups have been very up in arms about the rule since it came out. So I'll let Marisa talk about the victory from the blockchain and crypto angle, and obviously those industries were upset by this rule as well, as they should be. The issue is the definition of dealer. A dealer is someone who has to be registered with the SEC. It's somewhat of an onerous process to go through. It's expensive. So whether you are a dealer or not is a big deal. Dealer is defined in the Exchange Act of 1934. What the SEC did in February is to pass a rule that added some meat on the bones, as the court said, created basically a whole new definition of dealer. As you know, when we talked to Suzanne Rose from the Alternative Investment Management Association, AMA, back in February, a lot of private fund managers felt they would be scooped up into this definition and have to register as dealers with the SEC. So two groups, including Marisa's, two groups of groups, filed two separate lawsuits in the Northern District of Texas. And what we're here to talk about today is two rulings that came out from the same judge last week, striking down the SEC's dealer rule definition. And I can tell you the hedge fund groups, in their case, the parallel case, which was brought by AMA and the Managed Funds Association, they were thrilled with this victory, and I think thrilled to have a parallel case that was brought by Marisa and the other members of the consortium in her case. So the rule is dead, and we'll see what happens next. But I think Marisa will speak to her side of the case.
Yeah, for sure. So I'm head of legal at the Blockchain Association, which is the largest trade association in the crypto digital asset space. And we brought the case along with a Texas-based organization called the Crypto Freedom Alliance of Texas. And they're based in the Fort Worth area. Both organizations have like a similar mission to essentially advocate for tailored regulation to push the crypto industry forward and allow innovation. And the finalized dealer rule was very problematic to that mission. From the crypto side, we felt like the rule was so broad that it would require a lot of people that engage with like DeFi protocols and provide liquidity to those protocols. It would require them to register as dealers, even though they were not offering any services to customers. They didn't even have customers. And it was so broad that it was possible that it could be interpreted as requiring a software developer to register as a dealer, which is like pretty absurd. And definitely not what Congress intended when they passed the act in 1934, although software developers weren't even a thing in 1934, but that's besides the point. So we got a great ruling. We actually jointly did oral argument in November, just a few weeks ago, with the Managed Funds Association and AMA, and split the time. And the judge came out with his opinions last week, essentially ruling that the rule exceeded the SEC's statutory authority. And really for the reason that I mentioned, that the groups that were suing and their members, there were no services being offered to customers. And the traditional definition of the dealer and how it's been interpreted for decades is that there are customers and there's services offered to those customers. So the SEC completely like changed the purpose and like how someone would be defined as a dealer, and that exceeded the authority granted to them by Congress. Interestingly, the judge did not like feel like he needed to reach the APA arguments. We had some very strong APA arguments because the commission really didn't address the commenters' concerns. Their cost benefit analysis was insufficient, but the judge, I mean, in order not to waste, more space, I guess, like he didn't need to reach it because he could vacate the rule on the statutory authority grounds.
Yeah, it was a very clean opinion. I mean, it was just, here's what the Exchange Act says, here's what the rule says. These words in the rule aren't anywhere in the statute or authorized by the statute.
Right.
And Marissa, I like your point about, the possible actors who could be swept up in this rule. You mentioned software developers, I mean, which would be a completely absurd result. In one of the judge's opinions, he said the Federal Reserve
Right.
might have been acting as an unregistered dealer for, for decades. So
that was my favorite part of the opinion. And the commission makes a point in the final rule to exclude the Fed.
Oh,
which,
interesting.
yeah, so they actually, recognized this rule is so broad that it could sweep up the government. So
Right.
let's make sure that they're specifically excluded. And the judge, really took that as evidence that the rule was broad.
Right, right. Well, you may have the distinction of having the final rule, SEC rule struck down of 2024. It's one of a distinguished line of rules that have been struck down this year. There is one more waiting that we talked about before we got on the short seller rule, but congratulations on your victory. Tom, I think maybe we leave it there.
One question, Marissa, do you expect an appeal to the Fifth Circuit?
I was thinking about it. I don't think so. I think they know they would lose.
Yeah, they would.
So
Yeah.
if they do appeal, I'm not too worried about the result, but I feel like it could be, I mean, it would not only drag the case on to the new chair of the SEC, because by the time there was oral argument, like Gensler will be gone. So I'd imagine they won't appeal.
Yeah, they may abandon the rule anyway. The new commission.
Right.
Well, Marissa, thank you so much for sharing the case and being with us today. Again, I add to Nick's congratulations. Nick, thank you.
Of course.
And hope you all have a wonderful holiday.
You too.